Hello dear students, today we shall discuss Kelsen's pure theory of law. Hans Kelsen, who was professor of law at the University of Vienna and judge of the Supreme Constitutional Court of Austria, published the pure theory of law in the Law Quarterly Review in the year 1934. This theory was further elaborated by him in 1945 in his General Theory of Law and State. The theory of Kelsen represents development in two directions. On the one hand, it marks the most refined development in the analytical positivism. On the other hand, it marks a reaction against the different approaches of the 20th century. Kelsen said, a theory of law must deal with law as actually laid down, not as it ought to be. This point earned him the title of positivist. While in the 19th century, the dominant trend in jurisprudence was positivism, in the 20th century, it was sociological jurisprudence. However, positivism has not died out in the 20th century, and the most important positivist theory of 20th century is Kelsen's pure theory of law. Before we consider the pure theory, it is necessary to dwell upon its historical background in jurisprudence. Till 18th century, jurisprudence was byproduct of theology, ethics and philosophy. The 19th century was the heyday of positivist jurisprudence. At the end of the 19th century, two main schools of jurisprudence sprouted up. One was sociological jurisprudence and the other was pure science of law. While the former emphasized relationship between law and social sciences, the latter advocated a rigid separation of law from social sciences. Kelsen applied the principles of elimination in his theory. Kelsen was extremely critical of sociological jurisprudence, natural law and Marxism. He said, in an utterly unscientific way, jurisprudence has become a hodgepodge of sociology, biology, ethics and theology. He propounded the principle of elimination. In brief, this principle states that if we wish to understand the law, we should eliminate all considerations of morality, equity, human nature and other meta-juridical ideas. Kelsen's approach is to free the law from metaphysical mist with which it has been covered at all times by speculation of justice or by the doctrine of jus nature. As regards sociological jurisprudence, Kelsen is of the view that it wrongly mixes up law with social sciences and thus creates confusion. Natural law is condemned as with it one can prove everything and nothing. Marxism is rejected as it introduces ideology in law. In this way, by discarding all extraneous considerations, Kelsen has sought to create a pure system of law. He wanted to give us an unadulterated law. He wanted to create a pure science of law completely divorced from the other social sciences. Jurisprudence is concerned with legal norms emptied of all political contents, all questions of ethics or social philosophy being beyond the jurist's ken. He based jurisprudence on the theory of norms, which he wished must be followed by the state. Kelsen said that a theory of law must remain free from politics, ethics, sociology, history, etc. In other words, it must be pure. He wished to keep legal theory free from all extraneous non-legal factors. He said uncritically, the science of law has been mixed with elements of psychology, sociology, ethics and political theory. He sought to restore the purity of law by eliminating all meta-juridical ideas from the province of jurisprudence. Thus, he wanted to give us a pure theory of law. So, Kelsen described jurisprudence as normative science. He regards jurisprudence as normative science as distinguished from a natural science. In natural sciences, laws are statements of the sequence of cause and effect. That is, if X happens, Y must happen. In jurisprudence, laws do not have a causal connection. They have a normative connection. That is, if X happens, Y ought to happen. For example, take a legal proposition that if a person commits murder, he ought to be hanged. This proposition remains valid even when it is infringed and even when the indicated consequence has not followed. The legal order, according to Kelsen, is not based on the cause and effect principle. For example, the punishment should be inflicted for committing a crime by violating a provision of the penal code. In fact, a large number of crimes go unpunished. There is no cause and effect relationship between the crime and the punishment. Therefore, jurisprudence is a normative science. Legal system has been described by Kelsen as pyramid of norms. Kelsen viewed law as hierarchy of norms. According to him, the objects of science of law are those norms which have the character of legal norms and which make certain acts legal or illegal. The term norm means that something ought to be or ought to happen, especially that a human being ought to behave in a certain way. This definition of norm is, however, also applicable to moral or religious norms. According to Kelsen, it is characteristic of legal norm that it prescribes a certain human behavior by attaching to the contrary behavior a coercive act as a sanction. The pure theory of law considers element of coercion as an essential ingredient of the concept of law. Kelsen says, law is a coercive order of human behavior. A norm is a proposition in hypothetical form. If X happens, then Y ought to happen. For example, if a person commits theft, he ought to be punished. Even though in a given case, events may not work out according to the legal ought, that does not invalidate it. X may commit theft but go unpunished, for he may escape from detection. He may bribe the officials who administer the law, or he may die. Even though any of these things may happen, the proposition that if a person commits theft, he ought to be punished remains good. According to Kelsen, the legal order is not a system of coordinated norms of equal level, but a hierarchy of different levels of legal norms. A legal norm is valid if it has been authorized by another legal norm of higher rank. Thus, an administrative order is valid if it corresponds with the rules. Rules are valid if they correspond with the act, and the act is valid if it corresponds with the provisions of the Constitution. The Constitution is valid if its making was authorized by an earlier Constitution. But if a Constitution is the first Constitution of a new country, there is no positive source of law from which it can derive its validity. In that event, Kelsen resorts to the notion of a grand norm, that is, basic norm or fundamental norm. The grand norm is considered by Kelsen as the ultimate source for the validity of all norms that belong to the same legal system. Kelsen observes that any legal rule can be thus analyzed into a hierarchy of norms. Those norms are laid down by superior authority, but it is possible to trace the entire series of norms in a legal system from the initial or fundamental norm, which may be called the grand norm. Grand norm is the ultimate legal principle that validates the entire legal system. In this way, the legal system, as propounded by Kelsen, is closed at the top and opens at the bottom. Legal system is in the shape of pyramid. Kelsen characterized the grand norm as an initial hypothesis which expands and unfolds into various subsidiary norms. He says that a grand norm is recognized when it has secured a minimum of effectiveness, that is to say, when it has support of an effective group of people in the state. According to Kelsen's theory, in every legal system, there is hierarchy of norms leading up to a basic norm known as the grand norm. For instance, in India and in USA, the grand norm is the Constitution, and every other norm, whether created by statute, subordinate legislation, or executive order, in conflict with the Constitution will be invalid. In England, the grand norm is the principle of parliamentary supremacy. The chief merit of Kelsen's theory lies in the elucidation of the relation between the grand norm and the totality of legal norms derived from it. He characterized all laws as products of concretization of the grand norm. As the grand norm must reflect the basic political faith of the community, the conception that all laws are derived from the grand norm really means that law is concretization of the basic political faith. This theory explains the relation between the Constitution and all other laws. Kelsen's theory is different from positivism in two respects. It has a much wider sweep. It includes not only general norms like statutes and rules, but also individual norms which are created by wills, contracts, and even court decisions. Kelsen calls a legal system as a system of norms instead of a system of rules. The word rule has a general connotation, whereas Kelsen includes within the category of norms court decisions, wills, contracts, etc., which create individual norms and not rules. Let us take up the distinction between Kelsen's theory and Austin's theory. Kelsen has recognized the broad similarities between his pure theory and the imperative theory of Austin, but has equally emphasized the differences. The 7 points of difference are as follows. First point, norm and command. Austin, by saying that law is a command of sovereign, punishable if disobeyed, ignores the normative character of legal rules. Kelsen does not regard law to be the command of the sovereign. First, he rejected the idea of command because it introduces psychological element into a theory of law, which should, in his view, be pure. Austinian notion introduced a subjective political element in the concept of law. According to Kelsen, jurisprudence is not concerned with the source of law, whether it has emanated from a sovereign or custom or some other source. The second point, sanctions. Kelsen agreed with Austin that a legal norm derives its validity from the state and its force from the sanction attached to it. Kelsen did not view sanction as something outside the law, which imparted force to law as Austin did. Kelsen analyzed sanction into rules of law. To Kelsen, the operation of the sanction itself depends on the operation of other rules of law. For example, take the proposition, none shall steal, lest he will be put into prison. In Austin's analysis, prison term is the sanction attached to the command, none shall steal. In Kelsen analysis, none shall steal is a legal norm. It does not stand alone. Certain other legal norms are behind it, such as that if a man steals, he shall be brought to trial, that a trial shall be conducted such and such wise, that if he is found guilty, the judge shall sentence him to prison, and that the prison officers shall carry out the sentence. That is to say, in other words, one rule prescribes that if a man has committed theft, he ought to be arrested. Another prescribes that he ought to be brought to trial. Some other rules prescribe how the trial ought to be conducted. Another rule prescribes that if the jury brings into verdict of guilty, the judge ought to pass a sentence. And another prescribes that some official should carry that sentence into execution. Here the Austin's sanction is analyzed into several norms of law. In this way, the contrast between law and sanction in Austinian sense disappears. According to Kelsen, in the hierarchy of laws, it is only those at the lower level which are concrete that possess the attribute of sanction, whereas those at the higher level, which are abstract, do not possess this attribute. The third point, legal dynamics. Austin ignored the dynamic process of law creating, which occurs throughout the hierarchy of norms and which derives from the Constitution, whether written or unwritten. Kelsen says, at each level of the hierarchy, the content of norms may be developed on the basis of higher norms. This is a thoroughly dynamic principle. The fourth point, no dualism between state and law. Austin creates a dualism between the sovereign, that is state, and the legal order, that is law. To Austin, law is subordinate to the sovereign. The law emanates from the sovereign and so cannot control the sovereign. To Kelsen, the state is merely the personification of the legal order. The state is coextensive with the law. Kelsen identified state with law, as the state is nothing but a system of human behavior and social order, and every norm of social behavior is law. According to Kelsen, there can be no distinction between law and state. If you see it as organization, it is state, and if you see in terms of rules, it is law. Therefore, the difficulty faced by Austin of treating constitutional law, which binds the state as law in strict sense, does not arise for Kelsen. While Austin says that state creates the law, Kelsen would say that law regulates its own creation. The fifth point, customary law. Austin theory denies to custom the character of law as it has not been created by the sovereign. Kelsen, however, is able to accommodate custom within his concept of law, for all that is required to do so is an intermediate norm to the effect that popular practice may generate legal norms. However, customary law is also subject to grand norm. Sixth point, no dichotomy between private law and public law. Austinians draw a distinction between public law and private law. Public law is supposed to deal with the rights and duties of the sovereign or state, while private law is supposed to deal with the rights and duties of private persons. To Kelsen, this distinction is not meaningful. He denounced the distinction between private and public laws as both are concretization of the grand norm. Law is a pyramid of norms concerning relations of state with subjects, relation of public authorities with subjects, and ultimately relations between subjects themselves. In this analysis, Kelsen considered administrative acts of the state also as laws, because each such act is a concretization of some law. Judicial decisions are obviously laws because they are only laws to factual situations and therefore clear cases of concretization of laws. To Kelsen, the distinction between judicial and administrative acts is not real. Seventh point, nature of international law. Austin relegated international law to the realm of positive morality, contrary to the universally accepted usage of modern states and lawyers. Kelsen seeks to overcome this difficulty by demonstrating that state laws can be brought into the international order of norms so as to form one monistic system. Austin could not concede the status of law in strict sense to international law, because sovereign is not bound by law, which is only his creation. Kelsen's theory clears off this difficulty. The international organization is regarded by Kelsen as superior to the legal order, otherwise called the state, so its norms are binding upon the state. The denial of concept of state sovereignty has made this possible. Kelsen tried to establish international law as the real law of the states. He argued that the very recognition of two states as equals in law implies recognition of a higher authority which can bestow upon them the attribute of equality, which authority he called as the international order. Kelsen was of the view that there is a legal hierarchy and international law is at its top. Hence, a municipal law in conflict with a principle of international law will be invalid. Kelsen thus seeks to create a monistic world legal order. Kelsen's theory is not free from criticism. The 9 grounds of criticism are as follows. Lauterpat's criticism. Professor Lauterpat, a former student of Kelsen, has criticized the theory of his teacher on the ground that by accepting the primacy of international law over national law, a backdoor entry has been permitted by Kelsen to natural law. The lawness of international law cannot be derived from the grand norm itself. So, Kelsen's pure science of law has not demonstrated the lawness of international law, but has only assumed such lawness without proof. The second ground of criticism by Allen. C.K. Allen points out that sources of law like custom, precedent and statute are coordinate and do not admit of arrangement in a hierarchical pattern adopted by Kelsen. It is submitted that custom, precedent and statute are no doubt coordinate sources, but they are material sources. There can be only one formal source which confers the authority of law upon a given norm. That is the sovereign for Austin, it is the grand norm for Kelsen. The third point of criticism was by Friedman. Friedman points out that the task assigned to the pure science of law by Kelsen is inadequate from the point of view of legal theory. The sphere of the law is now intersecting the spheres traditionally allotted to other social sciences such as economics, psychology and sociology. So, analytical positivism is bound to give a way to a new preoccupation with social justice. It is submitted that this is not really a criticism, but an invitation to the Kelsenites to come out of their shells, throw off their self-imposed limitations and adopt the methods of sociological jurisprudence. The fourth point of criticism, scope of jurisprudence restricted. The basic defect in Kelsen's theory is that it unduly restricts the scope of jurisprudence to a study of legal norms alone. But unless we are to know the social circumstances, origins, etc. of a thing, we cannot understand it fully. As a matter of fact, in interpreting statutes, the historical background of the law should be seen. The pure theory of law without a sociological foundation is a sterile attempt for defining law. The fifth point of criticism is law is not an isolate. Professor Lasky too finds this theory impracticable. It is neither possible nor desirable to free law from politics and ideology. This theory appears to be an overreaction towards the modern theories of jurisprudence. The sixth point of criticism is origin of normative order unexplained. No doubt the achievement of Kelsen was that he introduced order in plethora of rules by suggesting the concept of hierarchy of norms headed by a grand norm. But Kelsen does not permit us to see how this normative order came about or by what social circumstances it is conditioned. In particular, he does not allow us to inquire into the origin of the grand norm. Such an inquiry, he says, does not belong to the sphere of jurisprudence, but to politics, history or sociology. The seventh point of criticism is purity of pure theory. Kelsen puts minimum of effectiveness as an essential feature of a grand norm, but it is impossible to assess the minimum of effectiveness except by an inquiry into political and social facts. When such an inquiry is undertaken, law is related to politics or sociology, and then the purity of the theory would disappear. The eighth point of criticism, natural law in disguise. Professor Julius Stone said that Kelsen's assertion that grand norm is essentially hypothesis or presumption amounts to no more than a theory of natural law in disguise. The ninth point of criticism is that not universally applicable. Kelsen's theory of grand norm is not universally applicable. What, for instance, is the grand norm in countries under army rule like Pakistan, and even in countries like USA and India? The truth is that the Supreme Court has often changed the Constitution, though ostensibly pretending to only interpret it. Should we then regard the grand norm in USA and India to be the Constitution or the decisions of the Supreme Court? In National Socialism and Fascism, effectiveness was the will of the leader and nothing more. Under the former Nazi system, the law courts were directed to disregard a statute and give effect to political ideology. Here, the grand norm is the supremacy of the leader's will. The tracing of a legal system as a pyramid of norms cannot apply to such a system, and Kelsen's theory cannot claim to cover it. This lesson is a small effort to explain Kelsen's contribution to legal theory and its merits and demerits. Thank you.